Greetings to everyone and welcome to this ELI webinar on a targeted revision of the European Union data protection law. I am Teresa Rodríguez de las Heras Bayel, the president of the European Law Institute, and I am absolutely delighted to have the opportunity to chair this webinar, where we are going to have a gathering of excellent professionals and colleagues, and we are going to discuss what we believe is a pioneer and very promising proposal for simplifying the data protection law in the European Union. As you know, we are going to have this webinar divided essentially in two main parts. After my introduction, that is going to be very brief, we are going to have a session that is devoted to explaining, but also commenting and analyzing this proposal. That is going to be thanks to the excellent participation of our panelists. Some of them are the co-authors of this proposal. This European Law Institute response to the public consultation on this matter. The other two comments that we are going to have, and we're definitely very honored and very grateful that both accepted, are going to be related to a third-party or external comment of experts that are going to analyze our proposal, but at the same time to add their insight and their views. That is going to be the main part of the webinar, and immediately after, I'm going to open the floor for discussion. We are going to have a significantly long period for a Q&A, and I'm really invite you all to have the opportunity to share your views and raise your question to the panelists. What I would like to do immediately is to very briefly contextualize what is this webinar about. It's going to be analyzed in detail by our scientific director, the main author, co-author of this proposal, because she has to indeed be the leader of this proposal that has had 6 co-authors, all of them absolutely fundamental in the development of this proposal. The context of this response of the ELI is this simplification strategy of the European Union Commission that is clearly aligned with the Draghi's report recommendation to ensure that the law, the European Union legal framework, is indeed promoting and enhancing the business and entrepreneurship in Europe, that we are promoting growth and competitiveness, innovation and prosperity, without definitely undermining the protection of the rights, without undermining the protection of the main interests, but at the same time ensuring that there is not a deterring or dissuasive regulatory burden on the side of the businesses. In this context, the response of the European Law Institute is pioneering in proposing a risk-based 3-layer approach in order to enhance the effectiveness, at the same time to reduce the burden of the data protection law in Europe. This is going to be discussed by the main co-authors, and that is the reason why what I would like to do is immediately to introduce our first panelist, Christiane Wenderhorst. She is professor of civil law at the University of Vienna, and she is the European Law Institute scientific director. She has been before, as you know very well, the ELI president, and she is the vice president of the Austrian Jurist Association and the president of the Humanities and Social Science Division of the Austrian Academy of Science. If I may, Christiane, I would like just to introduce very briefly Agathe Schliga, because she's going to be joining you in presenting this first part of the proposal. And Agathe Schliga, she's a partner of one of the most important and leading Poland's law firm. And I will try to pronounce definitely not well, but I will try. Szortyszynski, Kaveshi, and Schlesak, definitely not the best pronunciation. But Agatha, she's a partner in this important law firm. She worked on many areas, but particularly new technologies and personal data protection. She has been member of the expert group of the European Commission on business-to-business data sharing and cloud computing that we have the pleasure to be with you as both Christiane and myself, together with other co-authors of this response of the ELI to the public consultation of the Commission. Let me please give you the floor immediately. Christiane, I know that you are going to be the first one, so please, the floor is yours.
Well, thank you so much, Teresa. And it's a huge pleasure and also privilege for me to start with this presentation of the ELI's response to the consultation on the digital omnibus and digital package. The ELI would have had many points to cover when it comes to the digital omnibus and digital package, but we found one topic particularly pressing, and that is the data protection law in Europe. So we started with the Draghi report that sets out two main points of criticism. And those two main points of criticism with regard to data protection law are that first, there is no exemption for SMEs, and that data protection law as it stands could create an extraordinary burden for some of the SMEs who might not be sophisticated and not exactly active in the data economy, for whom data activities are not a core business activity. And the second criticism is that there are inconsistencies and that uncertainty may hamper AI development because of frictions between different legal instruments, but also inconsistencies between the implementation and interpretation given to the GDPR in the various member states. So next slide, please. This is why the European Law Institute Working Group came up with a plea for a three-layered regulatory regime. So what is the idea of that three-layered regulatory regime? It is inspired by the risk-based regime, which we find in many other recent pieces of legislation of the EU acquis, in particular by the AI Act, but also by the Digital Services Act. So on this slide, you see the three layers already illustrated with three, you see the three colors, right? You see in orange an enhanced regime, you see in green a light regime, and then you see in yellow a regular regime. And then click, please. So what is this risk-based regime about? So how to find out whether something is a high risk or a low risk activity. And you see here on that slide that it depends in the first place on the nature of data processing. So what kind of data processing are we talking about? And could we click, please, and see the next slide? We propose to have in an annex a harmonized list of high-risk data processing activities. So processing operations that pose a high risk to the fundamental rights of citizens per se. And that list should include items such as trading personal data. And needless to say, there should be a definition of trading personal data. And we propose such a definition in a different place. But also certain forms of profiling of natural persons, processing of personal data with a view to subjecting a natural person to a decision based solely on automated processing. We know that from Article 22 of the GDPR, but also processing of biometric data, genetic data, or personal data resulting from direct measurement of body functions, as well as the processing of personal data to record or infer sensitive characteristics or infer any differential treatment based on such sensitive characteristic. And that is, again, a concept we are well familiar with. And there are further points which I'm not going to mention here. Next slide, please. But the nature of the processing is just one criterion to find out whether something should be in the enhanced layer or in the light layer or in the regular layer. Another important dimension is, and click please, the scale and commercial purpose of data processing. And that is maybe even the primary criterion. And please note that I'm not talking here about large controllers of processing and small controllers and processing, because that wouldn't be accurate. It's large scale controllers of processing and small scale controllers and processing. Why do I stress and emphasize that it's about the scale? Because the criterion is the scale of data processing and the commercial purpose of data processing. And also, but only, as a second or third criterion, the size of a business. The size of a business does matter in some contexts, but primarily it's about the scale and the commercial purpose of data processing. And so the combination of these criteria then decides about whether you're in the enhanced layer, in the light layer, or in the big layer in between, the regular layer. Next slide, please. So who is in the enhanced layer? Well, it's a party processing personal data of, and now comes a figure which needs to be filled in by some legislator. It's not for us to take the political decision what that figure should be. In the printed version, we tentatively put 100,000 data subjects, but that could be too low. So that is just X. So it's a political decision how many data subjects is more. So anybody who processes X or more, the data of X or more data subjects at any given time is a large-scale controller, or a party that is designated as a gatekeeper. And in counting the data subjects, certain categories are not considered. For example, employees are not considered. So like a big manufacturer of machinery that has like very many employees, but otherwise doesn't engage in any processing of personal data, that would then not count as a large-scale controller. Now, what is the consequence of qualifying as a large-scale controller? Well, the consequence is enhanced duties. And why is this so? And why do we believe this should be the case? Well, we believe that a risk-based approach must not come at the expense of fundamental rights protection. So if we want to lower the regulatory burden, reduce the regulatory burden for the SMEs, the small-scale controllers, then we need to add and enhance fundamental rights protection where it is really required. And we believe it's required for large-scale controllers where those large-scale controllers engage in high-risk data processing. And where that is the case, additional measures, additional safeguards should be provided, such as that those large-scale controllers have to ensure effective consent management by data subjects, including by a delegated means, like you have a personal information management system, for example, that takes over management of your personal data, or any equivalent software, so that data subjects are enabled to manage their data by automated means. And then for the very big players and the data traders, additional requirements are imposed, like, or should be imposed, like registration or audits. Now click, please. Now, who is in the green layer and the light layer? Well, that is the MSMEs on the nonprofit organization. And again, it's a political question whether you want to include small mid-caps. And these are the smaller ones that do not process personal data of X or more. So it's those that do not qualify as a large-scale controller. So they don't process the personal data from so many data subjects at any given time, and for whom processing personal data is not a core business activity. So a small player who, however, has a core business activity in targeted commercial advertising, that would not qualify, would not benefit from the privilege. And so where you have such a small scale player, the GDPR applies only for high-risk processing. So only the processing operations you find in the list would be still under the regular GDPR regime. Otherwise, only very few selected requirements would still apply, such as lawfulness and data security, to ensure conformity with Article 8 of the Charter of Fundamental Rights. But those would be implemented through general laws, such as contract law or tort law. And then anything else in between would be still under the GDPR as it stands. So this is like the model. It's a layered regime, and the idea is that we reduce the regulatory burden for those players who do not create significant risks for data subjects and their fundamental rights, but that we enhance the protection for those players that do pose a significant risk, because we believe that the GDPR as it stands has its loopholes and its shortcomings in some respects. Next slide, please. So just to conclude, what would all this mean for an SME or an NPO, a nonprofit organization that wants to find out what this new regime would mean for them? So such an entity would have to check 4 things. So first of all, it would have to check that personal data processing is not one of their core business activities. And that will be relatively easy to find out. I mean, you know whether one of your core business activities is targeted commercial advertising or training AI or something. You know whether that's your core business activity. It's not terribly difficult to find out. Then the second thing they need to check is that they do not process personal data from X data subjects or more, excluding employees and some other categories, such as data which you process for the fulfillment of a transaction at any given time. Then, if both is positive, then sit down and identify, is there any kind of high-risk processing operations you may nevertheless engage in? Although you're a small-scale controller, maybe there is occasional customer profiling for commercial reasons, for example, and then you continue to apply the GDPR as usual for these operations. But for all other operations, just make sure they are lawful, that they comply with data security requirements and with the terms you have to comply with for providing services to others, such as a processor. But that is it. So it would mean a significant simplification for everyone covered by the light regime. And that is the idea. Of course, it's not the only idea which we propose. There are also further ideas, and I'm very happy to hand over now to Agata and then later Rania for our other proposals.
Thank you, Christiane. I will share the presentation, and I will be happy to discuss the prohibited and exempted practices. Let me see, just only to start the presentation mode. I hope it's visible right now. So when we talk about prohibited practices, the idea, of course, as Christiane said, comes from the AI Act. So the proposal intends to eliminate the processing, which would be a violation of principles of fairness, and as well could cause material harm to data subject or third parties. Of course, some of you may say that it is not needed because we have this concept of unlawful processing. But when analyzing this issue, we concluded that actually those two issues overlap, and not all unlawful processing would be prohibited. So indeed, there is a need for prohibited activities. The list is no long under the proposal, so we have actually 4 situations. One is applying misleading and aggressive practices to generate the data or to disclose the data, such as dark patterns or subliminal technologies. The other refers to a situation when the data controller or the data processor would rely on a purported consent in a situation when the disclosure of data or processing would lead to material harm on the part of a data subject, and really when in a situation when really the data subject would not decide to share the data or agree to sharing the data if the full information would be provided. The third issue when the third prohibited practice would refer to disclosing the data to third parties in case there is the data controller or processor knows or reasonably can expect that the recipient will breach the obligations towards the data subject and also cause significant damage. Then finally, the fourth one, which refers to actually designing the product or a service by the provider or manufacturer in such a way that the controller or processor using that would breach its obligations under data protection law. So these principles actually not always will be, those activities not always will fall into category of unlawful processing, but because of a potential harm, it's like in AI Act, it's recommended to prohibit them. Of course, prohibition will not apply in a situation when the provisions of the law clearly allow for such activities. And also the proposal says that indeed existing prohibition will remain in place, for example, coming from the consumer-related laws. But we are not talking only about the prohibited practices. As Christiane also said, we want to make some exemptions that clarify the situation. So the first topic we wanted to tackle is, of course, implementation of a recent ruling of European Court of Justice on pseudonymized data. So we say that actually we want to say in the proposal that if the regulation shall not apply if a processing due to technical or organizational reasons makes it impossible for the entity to identify the data subjects by means reasonably likely to be used. So we may have a situation when the processor is receiving the data, but if they don't have any technical or organizational reasons to identify the data subjects included in such data, there will be no obligation to apply the regulation. Of course, it will trigger a lot of questions about technical measures, about encryption, but that's something which will have to be decided. But it's important to state what the court said, that there is no obligation to rely on the regulation, to apply the regulation. Also, the second group of, I would say, simplification refers to the transitional processing. So, for example, we have a sensor which measures the congestion in the building, or the congestions in the road. They collect for a very short time the personal data, but they are eliminated afterwards, and the main purpose is not to identify the data subjects. So we will also, in order to promote innovation, the idea is that such processing will not apply, the regulation will not apply to such processing. Finally, we also the proposal also indicates and wants to eliminate various mundane processing, for example, in the business relations, when probably many of the participants experience that they receive a long information about processing of their data as a business contacts, as representatives of company, as a point of contact. So it's really not necessary to ensure to provide such regulation and apply GDPR in full scope to such processing. So these are the simplifications, as I said, it applies to those three situations. So as Christiane presented this 3-layer approach, I would only add the one on the top. So prohibited practices, they will be prohibited to all entities involved, both large scale, all parties in between, and small entities. And finally, I would I would like to talk briefly about Article 9, or a problem of Article 9, or it means processing of special categories of data, which cause a lot of practical concerns and practical problems. First, the proposal indicates that there will be, or proposes to add the definition of sensitive characteristics, which pretty much corresponds to the definition of special categories of data. You may see it's a little bit expanded. It includes also, for example, migration status or information about criminal convictions. But also, on the other hand, it also wants to make the life easier for the both controllers, processors, and data subjects, ensuring that proper level of protection is maintained. So at the moment, actually, every processing of special categories of data requires both consent, or other legal ground indicated in Article 9, Section Paragraph 2 of a GDPR, which is very difficult to achieve. And cause a lot of problems. So the idea presented in the proposal is that the processing of personal data, that will be allowed only in situations indicated in Article 9, Paragraph 2, if it applies to the biometric or genetic data in nature and allows unique identification of a natural person, if it concerns, if the data are inherently and specifically linked with sensitive characteristic, or if it's related to sensitive characteristic, in particular to record or infer. Then we will have such processing could be lawful only if the legal grounds listed in Paragraph 2 applies. And the new idea is also to add the 2 additional grounds. So the first one is a necessity to perform the contract or undertake actions necessary to perform the contract or to prepare to concluding the contract upon request of a data subject. In my personal view, it was really the legal ground which is very useful in such cases, for example, to prevent the fraud by processing biometric behavioral biometric. It can be a really useful instrument, and it would really not diminish the data subject's rights. And the second new legal ground is detection and mitigation of a bias and discrimination. It's very important, especially in the context of AI, which will be presented by Rania, because it's one of the inherent risks of AI solutions that they are really the one of the key risks is exactly bias detection and mitigation. So we need to have the instrument to tackle that without data subject consent or without the agreement. Thank you, and I will pass the presentation to Rania.
Thank you very much, Christiane and Agatha. As you can see, this refined and targeted proposal for the revision of the European Union data protection law has been benefited by the legal expertise and legal insight of the co-author, Christiane and Agatha, here together with Jussi Mäkinen and Paolo Balboni, but also, and this is important to introduce our next speaker, from the technical view of a data scientist and mathematician. So it is contrasted with the technical and technological analysis of this proposal. And that is the reason why I have the pleasure to invite Rania to present this technical perspective, in particular in relation to the requirement for the AI training in this context. Very briefly, Rania is a scientist and mathematician, data scientist and mathematician. She is the co-founder of a startup that is called Levant.ai that is dedicated to supporting companies and organizations with the development and deployment of trustworthy AI. Let me just mention 2 other things. She is the member of the advisory committee on the ethics of AI for the Austrian UNESCO Commission, and she indeed worked for prevent and mitigate algorithmic bias for the European Union Fundamental Rights Agency. So it has been a pleasure to count on her and her advice and comment. So please, Rania, the floor is yours. Rania.
Thank you very much. It's been a really great pleasure to work with all of you, and especially thank you to Christiane for this wonderful initiative. So it is my pleasure to talk about the combination of data and AI. So AI is a technology that is really hard to think about without thinking about data. So if we move to the next slide, maybe we can see all the different places where data impacts and interacts with AI system development. So, and for the purposes of this panel and for this discussion, it's useful to split the discussion in two parts. We have the part where the AI system is being developed, and at that point we're looking at training and test data. And then we'll have the part where the AI system is in operation, and we will be looking at that point at the interaction, input data, output data, and the algorithm itself. So let's start with the AI system development. And one of the, let's say, most prominent, most talked about kinds of AI that we hear about today are so-called large language models. And this type of AI system requires huge amounts of data. And this data is often collected in an indiscriminate manner, not particularly relating to data subjects or personal data. And so there is a question, well, is this possible? Are we allowed to use such kinds of data for training AI systems? And this is where the proposal comes in and really brings in what I feel is a very useful clarification. So the proposal is to allow data for training AI systems when we're talking about large indiscriminate amounts, when we're talking about data that is not related to the data subject as an identifiable person, and where the majority of the data can rely on legal grounds, but due to the immense amount of data that is being used, this may not be possible to verify or ascertain for every single data point. And so the exception is in the cases where such a verification is disproportionate, but there should still be appropriate safeguards for making sure the data is protected and complies with Article 5. And what I also find useful in this case is the specification that what is appropriate should be further clarified in delegated acts or in a standardization request. The other aspect, and this aspect is very important to me and my work in developing AI systems, is in order to be able to test these AI systems. And testing AI systems very often relies on the need for sensitive data, sensitive characteristics. So also here, the clarification that Agatha just mentioned is something that is actually fundamental in order to make sure that AI systems that are deployed are actually safe for everybody. So I think we can move to the next slide from here and discuss what happens when the AI system is deployed. And here, just an important point to remember that the AI system, even though it's not what we would normally consider as a data storage, actually contains embedded inside it a lot of data points. And so in many ways, you are still concerned about personal data that has been absorbed or is now embedded into the AI system or algorithm itself. And there are several issues that can arise. First of all, what happens when a data subject wants to exercise their rights according to GDPR with respect to the AI system? Now, technically, if somebody comes along and says, I want to be erased from your AI system, this is a very difficult task, and generally it would require retraining the whole AI system. So the proposal is to say the exercise of rights with respect to GDPR and with respect to the AI system itself, this is really important to remember, should be proportional to the amount of effort and should balance the harm from keeping the data inside the AI system with the amount of effort to remove it or to rectify the situation. If we click forward a sec. Another example of something that might be disproportionate is if, for example, the chatbot incorrectly shows your year of publication of the dissertation, correcting this error, which is a right, but correcting this error for the AI system itself would be disproportionate, potentially, regarding the impact on the person. But we know AI systems can have other and more detrimental impact. So if we click forwards, sometimes the AI system might take, for example, a journalist who often reports about criminal activities and associate them with the criminal activity, so that the output then will claim that this journal is the perpetrator of the crimes themselves. And in such a situation, the data subject absolutely does have the right to demand prompt and effective remediation. From the, oh, sorry, not yet. And another issue that is also handled in the proposal, and this is another important loophole, is that people have the right not to be cloned. So not to have an AI system which, without consent, for example, reproduces my gesticulations, my facial gestures, or to have an AI system which is reproducing my artistic content or literary style. So these are new and clear restrictions that are added in the proposal that I think are particularly useful and fill gaps in current GDPR legislation. So now we can move on. I think just to wrap up from my point of view, what this proposal does is take awareness of the current technical situation, what is currently feasible, what is not, and is also dealing in a practical way with new dangers that have arisen with the new technologies that we face. And with that, I would like to conclude and pass the floor back to you, Teresa.
Thank you, Rania. Thank you very much. So the three first speakers has provided a general, but as you can see, also detailed overview of the ELI proposal in this regard. I invite all the participants and attendees to read in full the document that you have available. But now the idea is let's contrast, let's discuss, let's gather other reflection and perspective. And we are extremely grateful and very pleased to have the opportunity to have with us two panelists, two speakers who are going to provide first the perspective of the European Centre for Digital Rights, and immediately after the perspective of the European Data Protection Board. So let me please introduce our next speaker, Max Schrems. Thank you very much for joining us today. As you know, Max is a lawyer, an author, but also an Austrian activist that is widely and very well known precisely because the campaign and the action against Facebook for its privacy infringement. And that is probably the reason why you are particularly well known. But you are also, in this regard, the founder of the non-for-profit association organization that is called None of Your Business, and is in the context of promoting the European Union data protection law, providing support and enhancing the effectiveness of these fundamental regulations. And if I may, in this context, I would like to give you the floor immediately. We are looking forward to listening your comment and your reflection on our ELI response. Please, Max, the floor is yours.
Cool. Thanks a lot for the invitation. Because I was asked, I'm not in a place that's dark. There's just a lot of sun coming from the back, so I had to close the curtains in this hotel room. First of all, thanks for the invitation. I'll probably start with some where we start with all of these reform debates. One thing I want to kind of highlight is there's usually now in Brussels, I call it the Draghi religion by now, because a former Goldman Sachs banker has given us a report, and now we all have to kind of follow that. And there are parts, obviously, that have a lot of sense in it, but I also have to say that there is very little evidence provided in a lot of these elements. There's one footnote saying SMEs are not especially treated. That's the evidence that's provided here. So I think that's important to highlight. We also looked into reform, as everybody knows, I think. And I think there's a lot of elements where we really need more evidence on where the problems really lie. There is a bit of a hyper focus on AI right now because everybody is in this AI frenzy and we all are terrified and sprints and I don't know what else and bubbles and every day there's another AI thing. So I think to do lawmaking in the long term, we have to look a little bit more at evidence. And we did, for example, ask more than 500 data protection officers that work real life in cases what their biggest problems are. And that is a lot of paperwork, a lot of inconsistencies in the law and so on. Very different stories oftentimes than what we hear right now. There may also be on really enforcement, things like profit skimming, for example. That's a huge thing for big tech. If the profits are still with you, you just run away even though you violated the law. So there's a lot of techniques that we have in other areas that we would really need to look into. What I see is with this proposal right now, probably start with where the agreement is. And I think with a lot of what Christiane, for example, has presented at the beginning with these 3 layers, with the high level approach of how to probably get to something, I think we'll probably agree 100% that, we have 3 layers, etc. That there can be then higher and a lower level of dependent on the sector. What I also think is important is to codify the risk-based approach. We're oftentimes just throwing out risk-based, but then an average lawyer in some small company sits there that has never seen the GDPR and has to now do risk assessments. That doesn't function. It doesn't help, especially the smaller controllers. Now, that all being said, I would probably jump over to the stuff where I fundamentally disagree. And that may be partly the AI situation. That is something where I think we're partly on the wrong track. A lot of the reasons why we have the GDPR is, if you look at the 1980s of why we came up with these principles, people had the idea of there's going to be a system that just going to sucks up tons of data, is going to spit up something else and makes decision. No one understands why anymore. So we need all these rights. And that is way before I was born, luckily. Now we are at that point where a system like that exists that we call AI. And now to jump to the conclusion that therefore we have to get rid of all these principles is, to me, a bit of a circular approach. And so I'm going to go into that a bit more in detail. If we go to the overall feeling I have is the proposal here is not a targeted reform. This is just not what this is. This a colleague of mine called it an atomic bomb thrown at the GDPR. At least it's a radical reform. Let's agree on this. It's definitely not a targeted reform. It's fundamentally changing the whole system as we have. If we start with the SMEs. Now, on the SMEs, they are, just to be frank about what we're talking about here, the SMA definition is 99% of European businesses. That's not a small part. That is the vast majority of everybody we're having. Now, it's also not that simple. When I reviewed the report over the weekend, I looked at the SME definition. It's not that simple. You just count, employees. You have to be part of the group, not part of the group, part of a university that is an independent research. It's quite complex. Then there are counter exemptions to the SME definition. So even knowing if you're an SME or not, for yourself may be possible, but for our data subject is not possible, because we don't have to publish, for example, employee numbers of people. So you can just say I'm an SME and no one can ever find out if you are one or not. So a lot of that in practice, if we would litigate that in practice, would throw tons of problems into litigation. To give you a couple of examples, SMEs are also very broad. I looked at Austria, for example, a bank we look into right now is Santander, like one of these online banks. They have 240 employees in Austria. Now you can discuss, are they group or not group, independent enough, whatnot. Or if you look at the Austrian banking system, Raiffeisen, which is a cooperative approach, saving banks in Europe are usually bottom up. They're really independent institutes. They have 50 employees. They're an SME under the definition. So a lot of that is really, let's say, if you apply it in practice, gets very weird results. Health insurance companies are partly SMEs. Doctors, hospitals, they would all fall under the SME definition by treaty default. I know there's counter exemptions with, saying that people are high risk processing and so on, but just the starting point is already quite broad. That's what I want to say here. Now, what is the solution for the SMEs that we see here is we're moving all of that into civil law. Now, the idea of what Draghi told us, we are too fragmented, it's all too complicated and so on. Now, imagine you make an access request under civil law. Now, I would say I have a right to access. Then we would have to figure out how far does that go? What's the timeline? What is included? What is not included? We don't have a law anymore because Article 15 wouldn't apply anymore. So de facto, any normal judge would probably look back at Article 15 and just apply that anyways, because what else is a judge going to do in that situation? So a lot of that in practice would then, have the impact with each national law. We're a small NGO, and we do have consumer contracts. So we have to apply the consumer law of all EU member states and then see how the German consumer law interacts with the GDPR and then come to a conclusion what the access right would be for that person. So simplification is probably not achieved at all with an approach like that. What's also just practically a huge problem is the DPAs wouldn't be falling under that anymore. I mean, to my understanding, they would fall outside all of that, so you can't go to Data Protection Authority anymore. Just to give you an idea, just an access request to litigate in Austria costs about 20,000 euros. So just that's the reality of removing DPA requirements here. So this is really very, very massive, these changes. And I think litigating that every day, we see that. Now, the counter argument is we're balancing that because we have a higher protection for the big guys and so on. And I fundamentally, approach-wise, agree, absolutely. But if we then look at what it is, we have, for example, the audits. We do know how the DMA audits work down. It's 20 pages where they say we're great, we're wonderful, and then there's someone proving that they're great and wonderful. So if audits aren't really having a serious consequence, in the proposal, for example, it says that the audit, if it doesn't come out positive, can be remedied and improved, and you can also not comply with the audits. So this is in reality, we know that, especially big tech companies, there is the huge conflict of interest of the auditor that is paid by it. We know the Wirecard situation. All of that can be remedied. There are options to make it tough enough that this is actually a tool that works. But the proposal we see right now, I don't think would remotely work and would remotely get anybody to actually comply more. So I think we would also, on this promise of more serious enforcement here, in reality, as a litigator and lawyer that does that every day, with each line, I'm like, oh, that's a way out, that's a way out, that's a way out. So I think there is really massive problems here. Now, last bit that I wanted to talk about is the specific processing activities. So the AI part that we heard, it's in reality a huge problem if we kind of privilege AI. And generally, I'm absolutely up for having a framework for AI that works and that allows it in a framework that makes sense. So I'm not fundamentally against regulating it. But privileging it would, to a certain extent, mean if you, and as the definition is here, take large amounts of data in an indiscriminate manner, so from a privacy perspective, then you're privileged. If you basically do that in a proper traditional database that is structured, where the risk is usually lower for the people, then you're not privileged and you fall under the normal system of the GDPR. So that is to a certain extent a situation where to argue that under Article 52, that this is actually necessary in the public interest to kind of do these privileges is going to be quite interesting how that would ever play out in the Court of Justice, if that would, the Court of Justice would accept that under the Charter. What's also quite interesting is the disproportionate effort here. I don't know about any rules where a fundamental right is not complied with because of a disproportionate effort. Like if it's disproportionately hard to, protect someone else's property, I cannot just steal it. That's just, the wording is really from a fundamental rights perspective, or if it's a disproportionate effort to give everybody the right to vote, it really is quite extreme in that sense. So I think for some of these elements, that's really kind of hard to do. Also for benchmarks and safeguards that I'm absolutely for. We don't have technical specifications yet. We don't have clarity of what this really means in practice so that we can actually prove and enforce that. One last bit I wanted to talk about is sensitive data and pseudonymization, because we see that trend now as well. On sensitive data, I understand the urge to say, if it's not directly information. So I'm gay, for example, I'm out since I'm 14. I would be protected because it's obvious. Now, a lot of my friends that are not out, they are terrified about random information around them that can disclose their sexual orientation. And that is exactly what we could potentially get out of the law here. If we say, if you can just deduct it, then you're not protected. So if someone has cancer, let's say, a lot of people don't want to share that. So if you can deduct that from the medicine and where you go and the treatment you do, is that covered or not covered? So the more we move into this, if it's not clearly, then exactly the wrong people, because the person that walks out and says, I have cancer, everybody to know, is protected, the other one not. That would be a bit of a problem. I know for the AI situation, that is that has another narrative, but for people, there is this problem. Last bit on pseudonymization, also something that I understand from the judgment we have and from the context of the judgment. But if we give more options for pseudonymization, we have to be aware that most IT products work with pseudonymous data. It's basically ID numbers. Online tracking is only ID numbers, where it's never identifying a person in that sense. So we do have in the GDPR this definition of singling out, which is very important in these things, but that contrasts with the idea of pseudonymous data, because you can still single out the person. And I'm just saying this may be useful for AI, but there may be whole other industry sectors where suddenly the GDPR wouldn't apply anymore if pseudonymization is, for example, something that we accept, again, with the different definitions we have. So I think for real life impact, we would, a colleague of mine said, if that's the law, we could shut down as Snoip tomorrow. So I would probably leave it as that was the final sentence for this understanding. Again, saying on the high level, I agree on the philosophical idea of how to approach this with layers and so on, absolutely. With the actual wording we see in this proposal, good luck. But I hope I'll leave it at that. And that was somewhat useful, even though maybe a very black and white contrast to what we heard before.
Max, thank you very much. We very much appreciate this critical analysis and the fact that you have raised probably a question, but at the same time, points that required further clarification. So indeed, we are going to have the opportunity for Christiane, Agatha, and Rania to come back to your question and add, clarify, or start a dialogue in those interesting points that you have raised. So thank you very much for being with us today. And I have the pleasure to give the floor to our last speaker. We are going to have the pleasure to have with us Isabel Verrieken. She is the head of the Secretariat of the European Data Protection Board. That probably condenses all her legal expertise and background. So I think that is extremely relevant if I refer to you with this particular affiliation first. But let me just please add that you have been previously a legal advisor at the Belgian Data Protection Authority. So definitely we are very happy to have you, and I would like to invite you to share with us this perspective from the European Data Protection Board. So please, Isabel, thank you for joining, and please, the floor is yours.
Thank you very much for the invitation, Teresa. Do you hear me well? It was well, yeah? Okay, perfect. So I just would like first to come back on the fundamental belief from the EDPB, on also the good element that has been brought by the GDPR. I think that is also important to underline, because the EDPB believe that it has strengthened, modernized, and also harmonized data protection principles across the EU. It was, in fact, a great improvement compared to the Directive 95/46. It has reinforced the rights of individuals, and also, in fact, it has forced companies to be a bit more accountable. It has been based, many of the principles were already the same as the Directive 95/46, but the difference is that they were more competent for DPA to enforce the rules, and also more fines, in fact, that motivated the business also to comply, because in the past it was a bit more as a theoretical right, while in fact now it became a bit more practical. You can see that there are much more also litigation on the matter. But it was based on those principles. There were also more cooperation between authorities. In the past, when there were some cross-border activities, it was more for the law firm to try to reach different DPAs, to understand the perspective, and to try to reach a consensus and to find a consistent way of working. While right now the burden is on the side of the DPAs that needs to cooperate and then to provide with a single answer when they are enforcing. The awareness of the right was something that was quite significant. I think I'm not aware of another EU law that has such a major impact of being known by everybody in the EU. It was really amazing, and I think it's important relating to a fundamental right. I would like to underline that it is risk-based approach in my view, because there were like some reference, I think, that it was not the case, but you can see that in chapter 4, for instance, in all the duties, there is a lot of reference to risk-based approach. And I would like to say that I agree with what Max has said on the fact that what it's also important is to have here some kind of legal certainty, because we have seen also during the negotiation of the GDPR that there were some pressure for the business to have more risk-based approach and also accountability, meaning that let us to decide how we are going to apply the rules and don't be so precise in the text, etc. But then while the text is out, then it can become extremely difficult for the business to understand, in fact, to conduct this risk-based, this risk analysis, and then to understand precisely which rules need to be applied. And then after, they expect a very high level of explanation from the DPAs, while they to provide some kind of legal certainty for conducting their business. The GDPR, nevertheless, also have been, in fact, a bit overwhelming, especially for SMEs, and then indeed they are the backbone of the economy. In some of the countries, it's only SMEs, in fact. When we had this discussion about the record of processing within the DPB, we were discussing, there were some DPAs expressing the fact that, in fact, the whole private sector would be covered by the new exemption. There will be none of them that would go above the threshold that was provided by the legislation. So at the DPB, what we have done, I mean, this is also something that is also important. We try, in fact, to provide support to the business. Since the 2018, we produced more than 50 guidance and recommendations to explain the legal framework. But we also did some years ago an entire section on our website. It was a handbook for SMEs to explain the GDPR in a very easy manner. It has been translated, I think, in 19 languages. It's also translated in South Korean or Chinese, or it's really used even, I would say, beyond the framework, because it's apparently it's been considered useful also abroad. But then in July 25, all the commissioner in the EDPB decided to have a special meeting in Helsinki with all the top level manager to discuss what can be done to make GDPR compliance easier, but also to have more consistency, to be more transparent and also collaborative. So there were some different, so we issued a statement on that in July, beginning of July. One of the aspects was to have the GDPR that was made easy, to have, in fact, shorter guidance, more timely, to also develop some practical tools like templates, checklists. I would like to underline that today, normally I think it will be today, we will launch a public consultation on that, because we we thought that templates can be useful, for instance, for data breach notification or DPIA, but we also decided to launch a public consultation to get, in fact, the needs from the external and the business on those templates. And so we are going to launch that today. This is one of the actions that has been underlined as being very important from, for instance, it was the dialogue that was conducted by Commissioner McGrath also in July, which was in fact where the companies present, NGOs and academic, were quite supportive of this Helsinki statement, but also underline the need of practical tools to improve GDPR compliance, to make it easier, in fact, for those smaller actors. Then we also decided to have more exchanges with stakeholders, so as I said, also for the idea of the templates, but also not only to hear stakeholders at the end of the process when we have already adopted a set of guidelines, but also earlier, eventually, to be able to take their views into consideration or to understand which are the examples on which they would like to get clear information. We will also open our website a possibility to flag inconsistencies, because it has been raised that there are a problem of inconsistencies, but really when we looked also into the details of, for instance, the Commission report that was made, the second report on GDPR implementation, there are very, very few examples, maybe only one, of inconsistency. And for us, it's a bit complex to look at the website on the daily basis of all the DPAs in all different languages and try to flag where there would be an inconsistency. So we will open up also externally to gather this information from outside. To also increase, I would say, the quality of consistency, the DPA is also committed to prioritize the work at European level when there are strategic cross-border matters. So instead of when there is something new, very important, touching everybody, instead of starting to work at national guidance on the matter, and then the EPB later on has to ensure consistency, to in fact start from scratch at European level. We, as an example of this exchange with stakeholders, we also committed to have an event on the SRB case, because we already adopted a set of guidelines on pseudonymization, and we were also about to make the one on anonymization, but we were waiting for this ruling, and we decided that there is a need also to have a stakeholder exchange on the matter that will be in the coming weeks. I think that's important. And maybe, by the way, I would like also to provide a feedback to Max on the concept of pseudonymized data, because this is something on what I worked a lot when it was the GDPR negotiation. It was the first time when we introduced the word pseudonymization. And you would see that in the GDPR, it's not so much pseudonymized data, but it's pseudonymization which is used, and also in the ruling, because we are talking about data that are directly personal at the beginning, and there is a reduction of information to, in fact, take out the direct identifier, like names or names, and then to replace by an alias the pseudonymization. And in my view, the circumstance under which you have in this advertiser business, they are like indirect information, other identifiers, in fact, to be able to single out individual. For me, we cannot call this pseudonymization because there is no reduction of information over there. Okay, that's just a parenthesis to I didn't resist to intervene on that. Then in the past, I would like also to flag that there were some critiques on the enforcement of the GDPR. This was really the motto everywhere in the press. And the EDPB also adopted a statement on that matter in Vienna to try to see what can be done in practice. In fact, what we do as well, instead of looking at the changing legal framework, is to make the best use of the legal framework and to see what can be improved. And so in Vienna, we did also that for the enforcement activities. And we have noticed that in the second report made by the Commission on the GDPR implementation, that there were a positive evolution that has been noticed by the Commission on the matter. So yeah, for instance, one of the actions that we made was to adopt the guidelines on Article 60, but also to have more cooperation, to in fact incentivize more cooperation from the beginning between the DPAs, etc. And this has really materialized and worked quite well right now. We also asked to change the national procedural laws, and then we made a wish list that has been transformed into procedural rules that, just for your record, still have to be officially published, and then this will be a change already enacted, I would say, of the GDPR that will probably come in practice in 2027. And then going also on your document of 40 pages with the legislative proposal on the GDPR. At the DPP, we do recognize that regulation, of course, can evolve. And for instance, we supported the change of the record of processing. It was asked by SME organization, this change. But also we thought it was good because it did not affect the core principle of the GDPR. Even if we cannot deny that the record of processing in practice is a very useful tool for DPOs within our organization. Then something that I would like to say is that as I raised earlier, I took part in this implementation dialogue that was organized by Commissioner McGrath in July 25. I was just an observer. I was not active over there. But I would like to report the fact, the Commission itself made a report, but there were many voices against general reopening of the GDPR. Why, in fact? Because they made reference first of the compliance effort that has already been made. If you would compare with the new legislation in the digital area, the compliance effort is quite new, etc. It's quite new and ongoing. While for the GDPR, the expenses have already been made. The fact also that the GDPR is a global standard is also used as a benchmark for international cooperation and also for making other legislation. And then on the fact that the GDPR is based on the Charter, this is something that you cannot forget. For instance, when there are critics, for instance, on severe rule on international transfers, but you would see that it was raised in this implementation dialogue that, in fact, most of the court decisions were based on the Charter rather than on the GDPR. So this is something that is quite important as an element. Then there were some suggestions for targeted changes, but underlining that they need to be all evidence-based, as Max said. The same outcome, in my knowledge, was also at the Council with the Member State. I took part in a meeting on the 10th of October, and EDPB, in fact, they as well received a strong support for the Helsinki statement as a way also to find solutions to the current issues. And there as well, there were also support for pragmatic tools such as templates and ready-to-use checklists. And I understand that's the road that the Commission will take right now, in fact. We found that we go too far will create the risk of legal certainty, but also disrupting the compliance efforts. And if you also put your energy into the change of the compliance effort, then you also divert your attention from innovation. Which is also something that is important to underline. So something that we also consider being important is to ensure the easiness of GDPR compliance, but also with the implementation of the other regulation, the other digital regulation, which is creating a lot of legal uncertainty, also with the interplay of the GDPR. And this is why this is also a very strong focus for the EDPB. We do work a lot on trying to provide guidance on the interplay between those legislation and the GDPR. We already made one on the DSA and the GDPR. We made a joint one with the Commission on the DMA and the GDPR, and we are currently also working very actively on the interplay between AI Act and the GDPR. We also launched one on the political advertising and GDPR, etc. We try to assist there to provide, in fact, legal certainty. On your proposal in practice, I do agree with Max that, in fact, they are not so targeted, but they go quite far. I cannot really share official views of the EDPB on the matter because the EDPB, they provide official position only on legislative proposal coming from the European Commission. But I can tell, for instance, that considering the legal basis, I will give some example. Considering the legal basis of the GDPR, for instance, if you do have these prohibited practices that was addressed to the creator, to the provider of product and services to the controller and processor, to say that it will be prohibited to provide those services and products if they would lead to unlawful processing of personal data. I would like to remind you that, in fact, the legal basis of the GDPR will not enable you, in fact, to regulate those providers. It's only controllers and processors that can be covered by the GDPR. This is something that was also discussed within the GDPR negotiation, and the GDPR went as far as possible with this recital addressing the designer of product and services. There is a recital where requesting them to respect the principle of privacy by design, but you will not find any trace in the article about that, because in fact it's legally impossible to regulate other actors than controllers and processors under that legal basis. Then on your proposal of a contract as legal basis for Article 9, I do remember quite well that this was already discussed at the Council. At that time, at least the member states decided to not go for it. Then on the AI, on the legal basis for AI, I would like to recall that we made an opinion in December 24, where we provided a kind of toolbox of how to use the legitimate interest as a legal basis, how it can be used or not, by providing a kind of matrix of all the elements that can be taken into consideration to, in fact, enable both the data protection authorities, but also the actor that are willing to train the AI model with the same criteria of assessment. And it has been used in practice by big players that decided to remove some type of data from the training, etc. For the limitation of rights in the context of AI, then I will go back on the fact that, for instance, right of access is coming from the Charter, and balancing this right with a commercial interest is something that is a bit delicate. There are also some Court of Justice ruling on the matter. I don't know, maybe you can look at to abuse of rights in the access right, etc., but just to balance the fact that there is a need to so of course AI needs to function. This is very important, etc. But to limit the right, I think it's quite difficult. I would like also to make reference to the same type of conversation that we can have in the copyright world, because the AI system and models are absorbed, in fact, all copyright materials, like songs, in fact, that were protected by copyrights, and they were, in fact, absorbed in the model to be able to develop free right music that can be used by people like supermarket, etc. And this will entail a big loss of money. In fact, we talk about millions and millions of euros that will be the impact. So it's important as well to take into the balance the consideration of the different actors. So to conclude, so the EDPB agrees that there should not be a general reopening of the GDPR, that the GDPR is a pillar of trust in the digital European economy, and the trust is facilitating innovation. For the rest, we are very active at the EDPB to implement the Helsinki Statement that we adopted in July, and we believe that smart regulation, clear guidance, and collaborative enforcement, Europe can then protect both citizens and empower its business, driving to a competitive digital future. Thank you.
Thank you, Isabel, for this very informative but also enlightening and suggestive comment that give us the opportunity to immediately open the debate. And before going to a list of questions that we have already received from the participant, I would like to give the floor first in the same order to Christiane, then Agatha and Rania, if you would like to add anything in relation to the point that has been raised by our speakers, Max and Isabel, in relation to the ELI proposal. Christiane, please.
Yeah, thank you so much. And it was precisely the idea of this panel to invite like the two biggest groups of opponents, right? Because it's not fun to have a panel with everybody praising what has been produced. So we knew exactly whom we would invite. maybe starting with you, Isabel. I mean, we really appreciate, and maybe that could have been expressed more clearly in the introduction, that we so much appreciate all those efforts that are being done for providing more guidance, for helping businesses out there, for doing all what you're doing. And I think this is so important and it needs to be done. Still, we felt that there are certain limits what you can do with guidance, and some obstacles you cannot overcome. And it's not just, we are not the people who only play this fiddle about, simplification and reducing regulatory burden. It's also, on the other hand, that we see those loopholes in the GDPR. We see that consent management doesn't work. We have the Data Governance Act now in place, but it all doesn't work. So we really want this to work. And that also takes me to artificial intelligence in a moment. We really want it to work. We don't want to reduce the level of protection. We don't want to create extra burden and uncertainty. We want it to work. Now that gets me to Max. Max, I know we're discussing very often these topics, right? So also outside this panel. So let me say, we mustn't approach the whole legal system and the economy just through data protection glasses. So if you just look at everything through your data protection glasses, that's what you will end up with. You say it's so difficult to find out whether one is an SME. Well, for most parties, it's not so difficult to find out whether they're an SME. There may be borderline cases, but then these borderline cases have to find out whether they qualify as SME for other reasons, because there's lots of legislation out there which you need to know whether you're an SME or you're not. So there are solutions for that, right? So it's not as difficult. And then, on the other hand, you say that we shouldn't we shouldn't try to just follow the AI logic and the AI bus, but that's exactly what we're not trying to do. With the legal basis and this rather balanced idea about data subject rights, we want to facilitate innovation where we believe protection is not required, but we want to enhance protection where we believe it is required, because currently the GDPR doesn't give you those rights in the event of generative AI. Then I know we have limited time, maybe just one more point. I'm glad that we agree on the general approach, that we agree on the 3 levels, and you and I debate a lot about that. I think we may not entirely agree on how to define it exactly, but we're in agreement there, and I think that is good. One thing that really puzzled me was the audits, because when we had that first draft last year, your criticism was we should have the audits for the high risk and the large scale players. And now we added the audits thanks to Max Schrems, and now you credit the audits. So we really need to discuss that in another scenario. Okay.
If I may respond for 30 seconds, being mindful of the time. One of the things with the definitions, absolutely that it's possible to find out. But in reality, one important thing is we're looking from an academic perspective, that we have all the information, but in practical litigation, you don't. The data subject and also the data protection authorities, largely, to be frank, do not have the information. And companies are very good at hiding them. So for example, a lot of these companies just finding out, are you established in Ireland or not? You would have to hire a private investigator sometimes to figure out where decisions are really made and where the headquarter really is. So objectively, it's well defined, but in practical work, it's very hard to get these elements into line, especially because companies just lie. Like largely in most cases, they just blatantly lie. So that is what I meant. I'm aware, just to be sure what we mean. It's not about objectively being able to define it, but to in practice proof it. And that's a different story. On the audits, I agree. Like audits, I think is a great thing and we should do them, but they would have to be harsh. Like they would have to actually have consequences. And, in financial audits, we publish them. If you don't get attestation, all investors are gone tomorrow. So that has a consequence. Not if you just get an internal report that, you're going to be like, yeah, nice, we're going to do something or not. That's a very different thing. So even if we agree on the audit word, the question is how it's implemented, I think.
Yeah, so maybe I will jump in on SMEs. I think it's not exactly that difficult to define. I agree that there may be cases that's really complicated with partner enterprises and subsidiaries, but in fact, most of the member states give the possibility to check financial statements. And because the definition as a basic is based on a turnover and number of employees, you can, or revenue, you can dig that out rather from the websites or from the official registers. Of course, I agree, but sometimes it may be difficult, especially with partner enterprises, funds, investing. It's really a mess to define it. And sometimes we have a question and we consider very carefully whether it is, for example, for portfolio companies and the portfolio of investment funds. But it's a general problem of SME definition in the whole European law, because it applies also in a competition law. But I think also we need to answer the question, what is the reality of compliance with personal data protection rules by SMEs? And I think also the purpose was to make it a real obligation, a real compliance, because in my experience, most, especially small enterprises, they don't comply at all with these regulations. So if we reduce the burden, we increase the chances they will indeed comply. And I think it's really relevant to, at the end, ensure that compliance. On pseudonymization, I honestly very like the decision of the court, because, for example, for me, I will give you an example. We have a bus manufacturer. They are collecting geolocation data because they provide the data as a set of data to the bus company, just to make the operation of the bus and verification of its technical situation, technical conditions. And there was a long discussion whether the bus manufacturer, who does not know who is driving that bus, is processing personal data. So I think if they don't have really a technical and organizational means to detect it, there is no camera, there is no login, and so on, they don't know who is driving that bus. For them, it's not a personal data. We should not assume that because simply they have a geolocation, they know who they are. And actually, for most of the processing, when I consider, for example, in cloud perspective, the processing contracts will remain in place, because it is a question of encryption, whether you have your own keys, whether you use the keys provided by the provider. So it will not be a straightforward, I would say, elimination of application of regulations to such data. And the final comment on sensitive characteristic, I think I personally liked the proposal, because indeed that tackles this issue of inferring data from others. So it clearly said that if your goal is to infer from other data the sensitive characteristics, you are allowed to do it only in the situation stated in Article 9, Section 2, which currently is not that, I would say, always clear-cut. We don't always have that clear-cut situation. And my final comment, I really think that having a contract as a legal base is really helpful, especially if we are thinking, for example, behavioral biometrics and other prevention and other activities. Even the COVID, I think, showed that there are really missing legal grounds for Article 9, and especially in enterprise relations. So really, I think the contract, maybe we should add some additional conditions, but it would be good to have a contract as a legal base. Thank you.
Thank you, Agatha. We only have 6 minutes before concluding. We need to conclude on time. There is a list of very interesting questions. What I'm going to do is just to pick up 2 or 3 main questions and give the floor to any of you who would like to intervene in a minute. So I'm going to start with Max. There is a question that is personally or directly addressed to you in relation to which extent your assessment would depend on the governance of the entity acting as processor. I don't know if you can read the entire question that is at the very end of the list. You would like to take a look, and maybe if you are ready to give your response.
I'm just trying to read it. It's a longer question. Yeah, on the government side, exactly, that is one of the things I think from, again, an intellectual perspective, super interesting. And I understand totally frustrating for a controller if they did that. The reality is on the outside, we hear that constantly as a defense. So, for example, you don't have a right to access because it falls outside of the scope of the GDPR. So you cannot even prove that it was properly pseudonymized, so to say. So a lot of that is chicken-egg issues that get produced here. And that is just in daily litigation. We also have to draw law for bad actors, not if everybody's happy and friendly. If everybody's happy and friendly, we wouldn't need law most of the time. We would just agree on everything in life. Law has to function for a stress situation, so to say. And so we see that in practice, that if you make an access request, not personal data, not stored, not retrievable, a malicious reason why you ask, blah, 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 you get the whole list, first of all, and then you have to dig through that. And that oftentimes, we have access requests that take 5 or 6 years to be answered in the current state of law without these exemptions. So, that's the reason why there is a lot of hesitancy to say, yes, sure, because everybody's a great actor and everybody is and everybody in this room I know comes from a good place and wants to do a good thing, absolutely. But we work with the people that are not good actors, and then that becomes very hard, especially to prove externally. That is where, back to the auditing, that could fix that gap. Because if we have a third party that proves that and says, actually, I approved it and I know it's properly pseudonymized, properly done, then we could actually build that trust that we can say, okay, the third party verified that. Other option as around is the DPA should investigate that. The reality is, I've not in a single case, we have 800 cases, seen a DPA actually going to a company, actually checking something on premises. I know that happens sometimes in ex officio investigations, but in the bulk of cases, it doesn't happen. It would be impossible for the DPAs to do as well. So that just in reality, we have to get these high level thinking that, on an abstract level makes sense into what works in practice and actually regulates, especially the bad actors as well, because they will just jump through these holes and be like, woohoo, I'm out,
Thank you, Max. If I may, can I maybe go to the first question that seems to be very specific to our proposal? If the fact that in the context of law enforcement, this personal data processing has not been considered high risk, and they ask, Xavier in particular asked, is there any specific reason for this option? Maybe can I ask please, Christiane or Agatha, please?
Yes, there is a specific reason, because law enforcement is under a specific directive. That's the law enforcement directive. That's not under the GDPR. That was the reason.
So thank you very much. I anticipated there was a very clear answer. And that is the reason why what we are going to do is thank to all the speakers for this excellent, insightful, and exactly fit for purpose webinar. We were expecting to have this dialogue, this conversation, this critical analysis of the proposal. Thank you very much for all the attendees and the participants for the excellent question. We hope that we will have the opportunity to come back to this proposal and discuss deeper, and then therefore we will have the occasion to discuss in more detail. Thank you very much, Isabel and Max. Thank you very much, Rania, Agatha, and Christiane, representing ELI and the co-authors. And I'm delighted to conclude this excellent webinar, thanking again for your participation. Thank you.
Thank you.